We are going to start with the paper of yours, The Legal Empowerment of the Poor, Access to Justice. Let me start by asking uh, why this paper? Why did you decide to prepare this paper?
Well, at a certain point in time, the United Nations set up a commission on the legal empowerment of the poor. Basically, what they had said was problems of poverty are based on the legal system, and therefore we need to resolve that. So at that time, the famous Peruvian economist and the former US Secretary of State, both of them became the commission members, and they had selected a few African countries to be a test case to promote the legal empowerment of the poor. And one of them, the projects was one thing that I was leading. So the main focus of the legal empowerment of the poor had four components. One of them is access to justice, that the poor have access to justice. The second thing is property rights. The third area is labor rights. And the fourth area is entrepreneurship rights. These are basically the missing elements in developing a poverty-free world and a poverty-free continent. So to this end, we had specific questions, and we undertook research in the four areas, especially in Ethiopia, and this paper is only one of them, that is access to justice. We have three other papers that have been developed in this arena. And I think the most important thing in this is most of Africa's legal regimes have been copied from colonial countries, basically the UK, France, or probably Portugal. And therefore, from the philosophy of law, when we look at jurisprudence, law must reflect society's ambitions, society's behavior, social interactions, and of course, society's beliefs. But these legal regimes were superimposed on African communities that didn't have the same social background as the laws that were made in Europe. The second thing, Africa had communities and associational life before the Renaissance in Europe. And people have adopted various legal regimes that control the social life in Africa in different communities. For example, in the Ethiopian case, we found the Gada system, the Baito system, and other systems in which communities still regulate their own activities through them. Since most of the legal regimes that have been introduced after probably Second World War are not even in place for most people. The courts that you see in Africa, you find them in the capital cities or in major towns. Otherwise, the rural areas are completely devoid of any kind of law enforcement, except that you have the military to look after the borders of the country. But we don't have this kind of organized courts, organized law enforcement in the rural areas. And much of Africa's governments don't have any control over the rural areas anyway. So what was important was to look into how access to justice could be delivered to the majority of the poor people. And in this case, we saw what are the potential for reviewing our legal regimes using sociological and anthropological studies that would inform the kind of laws that we're going to have in our penal and civil courts. So this is the background for the whole thing. Thank you.
Thank you very much. Like I was just trying to allude to, this is a very important conversation. And of course, in the course of the conversation, I'm going to be touching different area. But just now, before I even move beyond this paper, because I see it to be a very important paper, this one that you have written, as it deals with law and also the research that you have carried out. I'm trying to understand. If you were to say this is the central message of this paper, what would you call it?
Well, one thing is for sure, the legal regimes that we have in Africa today don't support the poor. In fact, the poor are the victims of the legal regimes we have. We hear about land grabs in Africa. Huge amounts of land are taken, agricultural land is being taken by different corporations from abroad. We hear about building of dams, building of roads, building of electric networks that go through indigenous people's lands, and these have no benefits to the local people that are being displaced because of these development projects. And I think no major work has been done so far in Africa to this effect. We have more than 50 million indigenous people in Africa, and all these infrastructure projects that are being built have not taken care of the needs and aspirations of those people. Of course, development has to happen, there is no question about it. But the point is, what are these people who are displaced from their own communities, from their own cultures, going to happen to them? Are they going to have alternative lands? Are they going to benefit from these development initiatives? Even in countries where you have minerals, like oil, diamonds, copper, and other things, local people have never been the beneficiaries of this. And therefore, even if local people want to complain to the legal authorities, they don't have any way of doing this. For one, much of the legal work globally needs a special expertise of what you call lawyers, who are very expensive even to hire. The second thing is all these rural communities in Africa might not even have the knowledge of how to go to court, how to find a lawyer, and how to pay them. So the central message is empowering the poor in a legal way means creating a situation in which the poor can have access to justice, be it through traditional forms of justice or be it through other forms of justice where the poor can actually afford and access justice to maintain their benefits from any development initiative that takes place or from any development initiative that the government has undertaken or will be undertaking on the side of the poor. So the central message is having the poor to have access to justice.
Okay, now that is about that for now from the book. Now I'm going to pretend I don't even understand what is meant by the rule of law. Maybe we are going to start from there. When people say rule of law, what are we even talking about to start with?
Well, when you talk about the rule of law orthodoxy, there are different kinds of rules that are developed in nations now. You have what you call the constitution, which is the upper hand law of a nation, where the Bill of Rights, that is the rights of every human being within that nation, could exercise, which are an important part of it, and of course, which defines the overall governance regime in any given country. The constitution is supposed to be written by the population at large, unless, of course, like what African leaders do, they will have always a referendum to change only one aspect of the constitution, and that is to prolong their terms, third term, fourth term, and everything. And this has resulted in different kinds of violence, including military coup d'etats and counter coup d'etats, as we have recently seen in Mali and Guinea. The second set of rules is the rules that are made by the what you call House of Representatives or parliaments. This House of Representatives or parliaments are supposed to be elected by the people directly, and therefore they make legislation and acts of parliament that would regulate society. The third areas are what you call directives that are authored by the Council of Ministers. These directives are there to interpret what the legislature or parliament has made into an act. But most often, the executive has broad powers in trying to redefine what the legislative acts are, sometimes contrary to the legislative act, and it has tremendous amount of leverage in terms of expanding its power. An ideal democracy would have an executive, which is running the country's affairs, a legislature, which is a lawmaking body, and the judiciary, which interprets the law. But definitely the executive is always the most powerful, trying to suspend the work or append the work of the judiciary and the work of the legislature. So the rule of law is basically adhering to the terms and conditions of the Constitution, legislated acts, and directives of the Council of Ministers.